Hello everyone, welcome to the second installment of our Reconnect webinar series. I'm Alexander Nemoylen from the Leuven Center for Global Governance Studies at KU Leuven, and I will be moderating this webinar on rule of law backsliding in the EU, what is it and what must be done about it, with Professor Laurent Pech and Dr. Justine Stefanelli. Laurent is Professor of European Law and Head of the Law and Politics Department at Middlesex University, London. His current primary area of research is rule of law backsliding in Europe. He is author of the book The European Union and its Constitution, From Rome to Lisbon, and among his most recent scientific publications are Illiberalism Within, Rule of Law Backsliding in the EU, with Professor Kim Shepperly, and Thinking Justice Outside the Docket, a critical assessment of reform of the EU's court system, with Professor Alberto Lemano. In 2018, he received the award for the Good Lobby Academic of the Year in recognition of his engagement and research on rule of law backsliding in the EU. Thank you, Laurent, for joining us today.
Thank you very much.
Justine holds a PhD from Queen Mary University of London and is Senior Research Fellow in European Law at the British Institute of International and Comparative Law, where she conducts research on rule of law issues in relation to the Council of Europe and the European Union, particularly in areas of immigration and asylum law. In 2015, she co-authored a report entitled Immigration Detention and the Rule of Law, Safeguarding Principles, and among her scientific publications is Strengthening the Rule of Law in the EU, the Council's Inaction, co-authored with Peter Oliver. Thank you also to you, Justine, for joining us today.
Thank you, Alex. Nice to be here.
So before we start, allow me just to say a few words about the Reconnect project. Reconnect is a 4-year multidisciplinary research project funded by the European Commission under the Horizon 2020 programme. It brings together 18 academic partners from across Europe and aims at reconciling Europe with its citizens through democracy and the rule of law. The goal that we have set ourselves is to explain and provide solutions to the deepening disconnect between the Union and its citizens in the context of recent crises, such as the challenges of migration, the economy, and security. As for the general structure of this webinar, first of all, Laurent will present for approximately 25 minutes. This will be followed by Justine's comments and a brief response from Laurent. So, during both presentations, you may send your questions to me via the webinar chat box. After the presentations, I will bring your thoughts and questions into the debate and allow Laurent and Justine to respond. So now it's my great pleasure to give the floor to Laurent, and I very much look forward to your presentation. Laurent, you have the floor.
Thank you very much. Yeah, it's a pleasure to be allowed to give a brief introduction to my main area of research these days, and best greetings from a sunny London, by the way, on what is a very important rule of law day. I don't know if some of you have seen this, but the European Commission has issued quite a few documents in the past hour and just announced the launch of a new infringement action against Polish authorities regarding the new disciplinary system they have set up for judges. I might just come back to this at the end of this presentation, but my main objective is more general in nature today. It's just essentially to explain what I mean by rule of law backsliding, what the EU institutions have tried to do to meet this challenge, and then I will also give you some of my personal thoughts on what possibly needs to be done in addition to what has been done already. But before we discuss how to deal with rule of law backsliding, perhaps we need to understand what I mean by that and why this is in fact an issue we need to be worried about. So let me also make clear, sorry, I'm just trying to get my slide to work. Okay, apologies for this. It was working 5 minutes ago. That's it.
Would you perhaps switch your camera on?
Okay, sorry, I forgot about this as well. I obviously need more coffee. So this is me having coffee in London.
That's excellent. Thank you very much.
Not very good coffee, I must say. But that being said, let me go back to rule of law backsliding in the EU. And according to a recent diagnosis by the Vice President for Jobs, Growth and Investment at the European Commission, countries like Poland, Hungary, and Romania are essentially deviating from the values on which the EU is based. And according to him, this is the biggest challenge the EU is currently facing, bigger than Brexit, for instance, or the so-called migration crisis. You don't have to agree, obviously, but this is very much my diagnosis as well. In fact, I made a similar diagnosis in 2016, soon after the European Commission for the very first time activated the so-called rule of law framework, a new instrument which the Commission adopted in 2014. So I believe we are facing essentially what I would say is an existential threat to the EU. To what extent is this an existential threat? Well, let me explain what I mean by rule of law backsliding. What you're looking at is a definition from an article you have mentioned at the bottom of the slide. So in 2017, with Kim Schepelet, a Princeton-based professor, we published a quite lengthy article trying to make sense of what we called rule of law backsliding. And in this article, we adopted the following definition, which you see summarized on the slide. So by rule of law backsliding, what do we mean? We mean, first and foremost, a process of dismantlement of checks and balances. What is the main difference between rule of law backsliding and the many rule of law shortcomings one can identify in many countries? It is indeed fair to say that there is no perfect country when it comes to compliance with the rule of law. There is always room for improvement. I'm not denying this. What makes rule of law backsliding, however, a problem of a very different nature than the usual rule of law shortcomings one may identify is that, in fact, this is a process where national authority deliberately try to make the situation worse from a rule of law point of view. So the intent aspect is quite important from the point of view of our definition. We have here, for rule of law backsliding, my understanding, or at least my definition, does mean that there is deliberate intent to essentially make the rule of law situation worse in a country. Now, how do you do that? Through different ways, which I will explore in the context of this presentation. But in most cases, you either capture existing institutions or you simply dismantle them or you just abolish them. Now, what is the long-term goal? And that's part of the definition as well. The long-term goal essentially is to establish a de facto one-party state. But the important aspect of the definition is the deliberate nature of this process. Essentially, it does imply that the situation was better before and is being undermined deliberately by national authorities, quite often under the guise of the will of the people. I will get back to the many arguments which are used to either justify or hide what I call rule of law backsliding later. But this is my definition of rule of law backsliding, and on the back of this definition, I believe we have at least, I would argue, at least 3 EU member states currently meeting this definition. Poland, which is subject to an Article 7 procedure. Hungary, which is also subject to an Article 7 procedure. And then I would argue now Romania is also meeting this definition. I'm not saying that no additional member states do not meet this definition, but from what I know, I would argue at the very least, these 3 EU member states, which are in fact the ones mentioned by the Vice President of the European Commission I previously quoted, do essentially represent clear examples of rule of law backsliding states. When was the problem first identified? When I talk about rule of law backsliding, this is not completely new. You could argue that the issue, it wasn't yet called rule of law backsliding in those days, but I would argue that the first time the problem was identified was 2012 by the former president of the European Commission in a very important speech in the State of the Union address, he referred in the speech to a new type of threats to the legal and democratic fabric in some of our European countries. In those days, 3 countries were mentioned or were discussed, Romania, Hungary, and also France. So to a large extent, I do agree with President Barroso that what we saw in the early 2010 was a new type of threats to the rule of law, what I call rule of law backsliding. I'm less convinced by the diagnosis he made at the same time, and whereby essentially he argued that we needed new instruments to deal with this new type of threats. According to President Barroso, Article 7, which he labeled rightly or wrongly the nuclear option, should not be used, because obviously you don't want to use nuclear weapons. Otherwise, when you do that, then the assumption is everyone is going to die. And then he said that infringement actions also are not very effective. Why? Just to summarize, because technically, strictly speaking, infringement actions, you need to challenge specific violations of EU law. If the threat to the rule of law falls outside the scope of EU law, normally, strictly speaking, you cannot initiate an infringement action. This, however, doesn't work. It's not an issue from the point of view of Article 7, because Article 7 does apply to any area of the law, including areas falling outside the scope of EU law. I'm being a bit technical here, but if that's unclear, you can always ask me a question later. But essentially, the diagnosis was we need a new instrument, and this new instrument was adopted by the Commission in 2014. It is known as the EU Rule of Law Framework. It was only used once in January 2016. It was activated by the Commission against Polish authorities because it didn't work out. Essentially, this new Rule of Law Framework does establish a formal structured dialogue. It's a framework, it's a discursive framework. But because the Commission and Polish government were unable to come to an agreement, the Commission felt no choice but to activate Article 7, Paragraph 1 of the TEU in December 2017. Moving on, I will get back to the EU rule of law instruments later, but I just like to give a quick update on rule of law backsliding in a number of countries. And I think it's quite useful to possibly visualize the problem. You have many studies, many rule of law indexes or studies or reports published every year. And what is quite striking is that what I have described as rule of law backsliding, we can see more and more evidence in more and more reports. What you're looking at, for instance, now is from Freedom House. And you can see 2 countries going on a downward spiral, if I may say. And it's particularly striking for Hungary. And also you can see that Poland, starting in 2016, fell quite considerably and quite quickly in this Freedom House index. Just let me mention in passing that this is a report only about Central European countries. This is not to say that other Western countries suffer from rule of law backsliding or do not suffer from rule of law backsliding. For instance, only a few days ago, Malta was discussed in the European Parliament. But I believe that as far as my definition of rule of law backsliding is concerned, Exhibit A is very much Hungary, Exhibit B is Poland, and then I would argue that Romania and Bulgaria are getting closer to meeting my definition as well. But the 2 most striking examples of rule of law backsliding are Hungary and Poland, and that's simply not, I will mention, in fact, all the reports now, because sometimes I get the counter argument that Freedom House is not objective. So, but if we look beyond the reports of Freedom House, in fact, we can see multiple reports, especially in the past few months, documenting the decline of the rule of law in Poland and Hungary, especially. What you're looking at here is the latest edition of the World Justice Project Rule of Law Index. Poland, when it comes to checks on government power, was the worst performer for the past 4 years, followed by Bosnia and Serbia. There was also a very interesting, short but interesting recent analysis of what's going on, the latest news coming out of Hungary, on the back of especially the ongoing the legislation which is about to reform or create new administrative courts in Hungary. As you can see, let's forget about Freedom House because it's sometimes criticized, even though there is no room. I mean, I don't think there are objective grounds for criticizing the Freedom House. But that being said, you can look at the World Justice Project analysis of the situation in Hungary. And as you can see, Hungary is ranked 24 out of 24 countries in the European and North American region. So there is plenty of evidence of rule of law backsliding in an increasing number of countries. In the EU, we have at least 2 striking examples, and these 2 countries are in fact subject to Article 7, Paragraph 1 proceedings. Now, just to explain what is Article 7, Paragraph 1 very quickly. This is supposed to be a preventive mechanism. So this is supposed to be activated in a situation where there is a serious threat to the values on which the EU is based in a specific member state. Article 7 of the TEU was inserted in the European treaties in the late 1990s. Initially, there was a fear, rightly or wrongly, that with the forthcoming enlargement of the EU in 2004, we needed a kind of a dissuasive mechanism to prevent, to actually dissuade new member states from backsliding post-accession. The assumption was, I think it's fair to say, that Article 7 would never be activated. In fact, that's why some people described it as a nuclear option. It's a bit like Article 50 and Brexit. No one really, I think, assumed that it would ever be activated. And what we saw in 2017 was, in fact, Article 50 and Article 7, Paragraph 1 of the TEU both activated in the same year. Interesting times, as the saying goes. Now, moving on, what should we worry about rule of law backsliding, assuming that you agree with me and that there is, in fact, rule of law backsliding in a number of European countries? What should we worry about it, let's say, for those, especially of us who do not live in Hungary and Poland? Well, what you're looking at here is essentially a summary of the main features of the EU legal system according to the Court of Justice itself. If I had to paraphrase, I would say that according to the Court of Justice, and I very much agree with the diagnosis of the description of the Court of Justice, the EU legal system is an interconnected ecosystem. It means that the rule of law situation in any member state is very important for the well functioning of the entire system, meaning that if one element of the EU legal system then starts being subject to what we call rule of law backsliding, then the health of the entire system becomes under threat. And this is very much why, essentially, every single EU candidate country has to show compliance with Article 2 TEU, meaning the treaty provision where you can see the values on which the EU is based. So the EU legal framework is very much based on this assumption that every single member state does comply and promote the values on which the EU is based. And this is not simply for purely conceptual normative reasons, but it is because very much without the rule of law in it protected and complied with in every single EU member state, then you threaten the very functioning of the entire EU legal system. And once you start undermining the functioning of the EU legal system, then by definition or automatically you're going to undermine the functioning of the EU single market. And if you do that, that's essentially the end of the EU as we know it. So I think it's fair to say that the Commission was right to be worried about the new type of threats President Barroso identified in 2012. Now, what has been done, before I tell you about EU rule of law instruments, and I know my time is running out, I just would like to share with you just very briefly some of the key features, the key practical features of rule of law backsliding. How does it happen and how is it defended? You have more information than I can cover in the context of this presentation here, but I guess you can read and work out this slide later. But I think it's quite important to understand that rule of law backsliding tends to follow, I would say, more or less the same blueprint or the same playbook, except that the playbook is being refined every time it is being used in a new country. In most cases, I would argue, the first step is always the same. Recently elected new government if they intend to undermine the rule of law, what are the first two steps they would take? Well, they would try to capture the constitutional court, if there is one in the relevant system, or at least the Supreme Court, and then try to capture or at least shape the media narrative. So either by capturing public broadcasting or by influencing indirectly public and private media. It's very important that you shape the public narrative at the same time that you are capturing the top courts of your legal system, because that way you can argue that while possibly you are violating the national constitution, and then it is legitimate for you to do so because, or let's say, to cite some of the usual arguments, this is what the will of the people does require from you. Or you can, quite often you hear that the judiciary is corrupt, or you can also, we have been told about the need to purge the national judiciary from communist judges. Obviously, it doesn't have to be evidence-based because, in fact, it's never evidence-based. The goal here is simply to establish a de facto one-party state, and all the arguments you can use to justify this end will be used. Another key important aspect of rule of law backsliding, at least in the European legal space, is that quite often national authorities intent on destroying the rule of law. What do? Is they pretend to be interested in a structured or not structured dialogue with EU institutions. Why is that important? Because while you're dialoguing, then European institutions tend to refrain from initiating legal actions. And this is very important if you want to undermine the rule of law, because then while dialoguing with EU institutions, you can then change the facts on the ground, and it's very then difficult, for instance, to remove unlawfully appointed judges after they have been appointed, regardless of whether the appointments have been made in compliance or not in compliance with the national constitution. And there are additional features which I have not time to summarize, but it's all there on the slide. Another possible last point I'd like to mention is that what we are seeing, and that's interesting as a lawyer specialized in comparative law, we can see quite often, at least Polish authorities and Hungarian authorities, relying on the case law of the German Constitutional Court to argue that what they're doing is in fact completely fine, because essentially if it's good enough for Germany, it should be good enough for them. And what do they mean by German case law? Essentially, they mean that EU law does not have to have primacy over national law when national law tries to reform the judiciary. But what we're talking here about is not reforming judiciary, is essentially the annihilation of judicial independence in order to transform judges in essentially organs of the ruling party. My time is limited, so let me move on to the main EU instruments available currently to address what I have called rule of law backsliding. I've used 2012 as a kind of a dividing line. Why 2012? Because that's when President Barroso issued or made the diagnosis previously mentioned about a new type of threats to the rule of law in the European legal space. So before 2012, we had enforcement actions. We had the so-called nuclear option, nothing new here. So what happened post 2012? I told you about the rule of law framework adopted in 2014. And in fact, today at 11, a bit earlier today, this morning, the Commission has issued a new communication asking people to comment or suggest rather concrete solutions or to make concrete suggestions on how to improve the rule of law framework. The same year, the Council this time adopted the so-called annual rule of law dialogue, and it's also my understanding that the Council is going to try to improve this tool before the end of this year as well. The rule of law framework has only been used once, as I told you before, against Poland. You could argue it hasn't worked because otherwise the Commission would not have activated Article 7, paragraph 1. The annual rule of law dialogue, in my view, hasn't worked at all, just because it's a rather modest tool. It aims simply to discuss a different topic within the Council every year. But there are no there are no consequences flowing out of this annual rule of law dialogue. The EU Justice Scoreboard is very instructive to the extent that it does provide with plenty of information about national judicial system, but again, this is just for information purposes only. What we have seen in the past 2 years is actually there's been a lot happening in the past 2 years to deal with rule of law backsliding. Because the rule of law framework hasn't worked really in the case of Poland, what we have seen is the Commission essentially relying on the old instrument, which is enforcement action, or also known as infringement action. It has been quite successfully used in the context of the Polish law relating to the Polish Supreme Court. So in fact, what we are seeing is possibly, I would have to oversimplify, in the past 2 years, we are seeing old remedies being used in a new fashion to address rule of law backsliding. And so as far as enforcement actions, I think what we are seeing is a new reliance on enforcement actions, which has been made easier, if I can put it that way, by a very important ruling of the Court of Justice known as the Portuguese Judges ruling in 2018, which is enabling the Commission to bring enforcement actions on the back of a treaty provision known as Article 19, paragraph 1 of the TEU. Essentially, this is where you can find the obligation for EU countries to make sure that they do not undermine or interfere with the independence of their national courts. So this is the principle of effective legal remedies in EU law. In the pipeline, we have plenty of new tools as well, or at least possible new tools. And I'd just like to mention very briefly the new draft regulation proposed by the Commission, which would allow, if adopted, and if not amended significantly, which would allow the Commission to suspend access to EU funding in a situation where there is a systemic deficiency as regards the rule of law. This notion of systemic deficiency is defined in the draft regulation, but this is potentially a very important development, but also a very controversial one, because this is essentially the first time there is an explicit direct link made between suspension of EU funding and the rule of law. Since my time is up, just very briefly regarding Article 7. Article 7 is quite often criticized for being ineffective. Why? The argument goes that sanctions will never be adopted under Article 7 because unanimity is required. And this is factually correct. And when you have two countries subject to Article 7 at the same time, then it's difficult to see how sanctions can be adopted, because obviously these two countries are likely to defend one another when it comes to sanctions under Article 7. That being said, the sanctioning arm of Article 7 is yet to be activated. What we are seeing in the EU today activated is the preventive arm of Article 7. In the best case scenario here, we would just have essentially the Council concluding that there is indeed a systemic threat to the rule of law in Poland and Hungary, but there are no direct sanctions which would be connected to this diagnosis. So that being said, I would argue that Article 7 TEU is not as ineffective as some people have claimed, even though it's quasi impossible to see sanctions being adopted on the back of Article 7. I would argue that the fact that Article 7 at EU was activated by the Commission regarding Poland and by the European Parliament regarding Hungary has actually helped crystallize the right environment, which has led essentially other EU and national actors to take decisive steps regarding the rule of law backsliding. For instance, I would argue that if it wasn't for the activation of Article 7 TEU, possibly the Court of Justice would have issued less, how could I put it, may not have been as bold as it was in the Portuguese judge's ruling. But I'm happy to take a question on this point. And this is just for your own information, but this is something I'm working on. I'm trying to essentially decide what is the best way to deal with rule of law backsliding, and I'm just working on the notion of an enforcement cocktail. Not as pleasant as drinking an actual cocktail, but essentially my position as of today is that rule of law backsliding is an existential issue which cannot be dealt with effectively by a single EU institution, and in fact not even all of the EU institutions were there to cooperate effectively together, which they are not currently, would not be enough. And I believe we need both national and EU actors to work together and address rule of law backsliding in a more coordinated manner than we have seen currently. And that does conclude my presentation today. So thank you very much.
Thank you, Laurent, for this very insightful analysis. I think we've all learnt a lot. Now I would like to ask Justine to share her thoughts with us on this topic. Before I give the floor to Justine, I would just like to remind our audience that we'll be soon moving on to the Q&A, so please do send us your questions for the discussion. Justine, go ahead.
Okay, thank you so much, Alex, and thanks, Laurent. I know it can sound like there's a slightly alarming state of affairs, but I think at least it's comforting to know that the EU knows that it should be taking some action, even if right now it hasn't quite hit on what is the best approach to tackling all of these problems. You know, it's still trying to be inventive, and Laurent, you already mentioned the Commission's proposal. I think it's an interesting way to tackle these issues. I know it's probably a little bit dead in the water because of the legal services opinion, but at least it is, you know, evidence that some of the institutions are trying to work hard to fight this issue. But more broadly, I think that what's happening in Hungary and Poland and Romania demonstrates that the rule of law is actually very fragile. It's not the case that once a country reaches peak rule of law compliance, whatever that is, but, you know, for example, through the EU's Copenhagen criteria, while member states are candidates going through the candidacy process, it's not the case that the member state can be left alone to its own devices and the other member states can relax, you know, safe in the knowledge that the current situation will persevere. We have to be vigilant all the time, and we have to be aware that backsliding might not always be so obvious, and it might not be taking place in the countries where you would assume that it might be. For example, you may tell from my accent that I'm American. Look at what's happening in the United States right now with the current administration and its action towards refugees and asylum seekers. And even what's happening in the UK with Brexit and the way that the people were arguably deceived by the leaders at the time. Both of these countries have slipped down in ranking on the World Justice Project scale. And Freedom House, which Laurent mentioned earlier, has commented that the US's recent disengagement with international efforts like the UN, for example, its treatment of migrants and the interferences that it has made with the independence of the federal judiciary have created quite stark rule of law decline. So the bottom line really is that the rule of law is potentially under threat everywhere, and we have to always be alert to that risk. I completely agree with Laurent's cocktail. I think it's important to apply a number of pressure points. Different tools should be available to attack the problem on multiple fronts. A range of approaches from soft dialogue to hard sanctions like Article 7. But I think it's really important to remember that when the soft approach fails, which it appears to be doing in the current situations, there has to be some sort of teeth that the EU can draw upon, whether it's the suspension of funds through a regulation like that that's being proposed, or if it's using Article 7. The EU is pretty unique in the sense among regional organizations, in the sense that it has enforcement powers and it can create legally binding obligations. The UN, for example, and its multiple treaty bodies don't have those kinds of powers. So they're an important tool, and they should be part of any rule of law mechanism that the EU decides to go with. There has to be clear consequences for a member state's failure to comply with the rule of law and with any soft approach. My next point picks up on something that was discussed while some of the Reconnect team was in Princeton last week doing some rule of law brainstorming that Laurent organized, actually. While we very much need the EU to take action on rule of law backsliding, there should simultaneously be action on the ground in member states. There's a really large role to play for national civil societies and educational institutions. And in many ways, this is a long game, but we need to educate our young citizens about the rule of law and why it's important. And we need to enhance the capacity of our civil society organizations so that they can effectively monitor the situation on the ground. And of course, we can do this financially, but we can also help teach them about the rule of law. Of course, some of these organizations might already be doing this and know very well what the rule of law is, but others may not necessarily, and they may not be able to identify how violations of the rule of law might impact their own work or even be manifested in their home state. And on the education front, many state schools include lessons about citizenship that focus on rights and responsibilities, that look at the voting processes, the electoral systems. But a lot of them don't focus on the rule of law, looking at issues like non-discrimination and access to justice. I think it's important that these lessons should be built into the curriculum at an early age. And here I'm going to plug a little bit the work that the Institute is doing to sort of make an impact on this front. We've been developing sets of teaching materials for kids ages 11 to 18, aimed at empowering them to become legally enabled democratic citizens. They teach things like understanding the justice system, how to empathize with those who have opposing views, and that's increasingly becoming more relevant today. And it sort of leads to my final point, which is a bit of a word of caution. These anti-democratic, anti-pluralist national authorities that we're seeing emerge, they do often represent the sentiments of some parts of society. Some people are dissatisfied with the status quo and they want change. And I think it's important that there's an outlet for those people to express those kinds of feelings in an open environment. But I think we still need to vigilantly watch for people or parties who might prey on the feelings to come to power rather than genuinely and constructively address the feelings themselves. So I think that's all I'm going to say, and I'll throw it back to Laurent if he has any immediate responses.
Thank you very much, Justine. Actually, we're very much in agreement. Just to go back to your education, civil society point, I very much agree with you. But then possibly what we need to be mindful of is that autocratic forces know also the importance of education and civil society, and which is why they tend also to target education, higher education institutions. I can just mention the CEU here very quickly. And they also tend to very quickly adopt legislation targeting civil society. Just again, we can refer here to the so-called Lex NGO, or the foreign funding legislation targeting civil society groups in Hungary. Mm-hmm. The goal here is to crush dissent. And so this is why I think we need, and in fact, the EU is just adopting new funding schemes to make it easier for civil society groups within the EU itself to gather funding directly from the EU to promote the values on which the EU and its member states are supposed to be based. So this is part of the long-term answer, I would argue, to rule of law backsliding, but we need short-term, more efficient and short-term answers. When the house is burning and we just simply cannot spend our time discussing the color of the painting or what needs to be done to build on stronger foundations. We need short-term, immediate, more meaningful and effective actions. And here I would argue we don't need to reinvent the wheel. We just have to keep doing what the Commission has been doing in the case of Poland and the case of Hungary, which is to initiate as many infringement actions as possible, and especially with respect to national judiciaries. This is a crucial part of the problem. If national courts are no longer independent, it's going to lead to massive issues. There is then no one left to make sure that corruption won't be increasing. There is no one left also to guarantee that free and fair elections will take place. So this is why we need more infringement action. I was quite heartened by this morning's news, for instance, that the Commission decided to bring a new infringement action regarding the increasing number of disciplinary proceedings brought against judges. I think this is the crux of the matter. I would argue, possibly, if I had the chance to make a concrete recommendation to the Commission, I would argue that possibly we should forget about the divide between soft and hard approaches. I would say we need to combine them from the very start. So I would argue, for instance, that as soon as the rule of law framework is activated, or Article 7, paragraph 1 of the TEU is activated, it should not prevent the Commission from initiating at the same time infringement actions regarding the aspects of the problem which fall within the scope of EU law. It's very important that we don't waste too much time dialoguing with institutions which are keen to undermine the rule of law and know exactly what they're doing. Because as I said, it's very important to act or prevent the facts from being changed on the ground, because then it's going to be more difficult to essentially unroll the damages at a later stage.
Laurent, can I suggest we move to the Q&A?
Sure.
Because we've received quite some questions which I think would be interesting to feed into the discussion. First of all, we have a question from L. Speyer, who is asking about the impact of rule of law's backsliding on domestic law, whether it leads to a more lax enforcement of criminal law in a domestic setting, or whether these procedures become more coercive. We've had a couple of questions on your enforcement cocktail, and particularly with regard to the fact that it focuses on political mechanism, political processes. What is the role of the European Court of Justice, for example? Do you value more? Do you think political processes are perhaps more effective? And this is from both Carrie Otterburn and Joanna Speyer. And the third question from Thomas Wace: what about when we see that the rule of law is neglected or weak in certain member states? So it doesn't perhaps go over the threshold of rule of law backsliding, but it is under threat. What kind of role can we see for the EU in these kinds of contexts? Please go ahead.
Plenty of interesting questions, but not easy ones either. But I guess they wouldn't be interesting if they were easy to answer. Regarding the implementation of law or the adoption and implementation of law in countries affected by what I call rule of law backsliding, the difficult question to quickly answer, I would say, from what I know, is that the impact is not widespread to the extent that usually national authority just like to have control over the judicial branch in order to directly or indirectly influence key cases. You don't have to have an impact on every single legal proceedings. The ruling party is just going to be keen to essentially make sure that the most important legal proceedings can be politically controlled. So regarding the implementation of law, what you can see is just kind of an ad hoc intervention when it is required according to the ruling party. And this is very difficult to detect because most of the time, obviously, this is done through informal means. You could, however, argue, that being said, that what backsliding authorities try to do is they try quite often to change the structure of the judicial branch. We have seen the concept of judicial reforms being used to, in fact, justify the adoption of a new framework, which leads to judicial decisions being controlled or being subject to possible control by political authorities. And I would say most likely this is the long-term impact of rule of law backsliding will make the judicial branch less effective, because what we are seeing as well is quite often ruling parties or those intent on dismantling the rule of law tend to target the most critical judges, which tend to quite often be the most competent ones, while promoting the most, how could I put it nicely, they tend also to promote judges or to appoint new judges which are keen to do the ruling party's bidding and not necessarily the most competent ones. So most likely what we're going to see is a less effective judicial branch. If you look at the situation in Poland, my understanding is that in fact the judicial reform which have been justified in the name of a better effectiveness of the judicial branch, and who would not agree with this goal, have led, in fact, to longer proceedings and therefore less effective, you could argue, judicial proceedings. So that's my answer to question one. Then question two was about, I guess, the link between legal processes and political processes. I would argue that one should not exclude the other. By political processes, I mean essentially, I would like to see more national governments making stronger, clearer public statements within the Council regarding the situation in other member states. I would like to see more heads of state and government raising rule of law issues when the European Council meets on a regular basis. I would like to see European political parties suspending or excluding national parties which are responsible for rule of law backsliding. I would like to see more national parliaments also expressing their views on rule of law backsliding in other countries. In fact, we have seen some examples. I remember, for instance, I attended a couple of weeks ago an hearing organized by the Dutch House of Representatives about the rule of law situation in Poland and Hungary. I think this is very healthy. We need essentially more peer pressure, politically speaking. We need also to support better the Commission, the European Commission. So, and I would argue that the Council has done possibly not what it should have done at the time of the rule of law framework adopted in 2014. Instead of lending its support to this instrument, the Council came up with its alternative tool. So we need more coordinated approach, and we need certainly all the national and European actors keen on protecting the rule of law to support one another. At the same time, I believe this is not enough. We need legal actions. By legal actions, I mean infringement actions. That would be my answer to question two. And then the third question was about, can you refresh my memory, Alex?
Yes, yes, it focused on the issue of when there is a weakening of the rule of law, but it doesn't constitute rule of law backsliding as such. Is there a role for the EU?
I would argue possibly that the EU should be mindful here of not overstepping the line. I think the EU should only step in when there is a clear threat to the values on which the EU is based. Otherwise, I would assume that the national legal system should be able to correct I should correct norm, if I can call it that, normal rule of law shortcomings. I would believe that the EU should only step in when the situation cannot be solved by the relevant national system itself.
Excellent, thank you very much. Justine, perhaps in 1 minute, a concluding comment, and then we have a quick second round of questions.
I think Laurent answered quite fully, but I would just say that on the sort of role of the ECJ enforcement cocktail thing, I was going to say a long time ago, but actually a couple of years ago, some colleagues and I wrote a report on rule of law monitoring, and one of the things we thought might be an essential ingredient was developing within the Commission some sort of rule of law task force that is monitoring what's going on in the member states, specifically with an eye towards bad behavior that is impacting the rule of law, and sort of launching a bunch of infringement actions that way. And then for the third question, I do agree that the EU needs to be mindful of when it interferes. I think, though, that this is probably where soft law dialogue comes in handy, informal discussions about what's going on. But also it's been suggested by some colleagues that there might be a role for the EU to play in routine and periodic monitoring of rule of law issues in the member states, sort of akin to what the UN does with its universal periodic review, so that everyone's getting monitored routinely, nobody will feel singled out, and if anything is identified as being worrisome, it can be hopefully resolved at an early stage.
Yeah, just to very quickly to follow up, I would have nothing against a permanent monitoring system of some sort. But I was talking mostly about enforcement. So I would say don't activate the rule of law framework unless obviously the national rule of law safeguards have ceased to function.
Mm-hmm.
Okay, we're coming towards the end of our webinar. Perhaps we have time for another couple of questions. First of all, we have a question from Christian Surbaro, who asks, obviously here we're talking about EU rule of law, but given the diversity of legal traditions that we see in different member states, can we really talk about a European rule of law? And perhaps this can be connected also to the impact of the communist or post-communist legacy that we have in Eastern Europe that was mentioned by Sławomira Miziak. And finally, perhaps again going back to your more recent work, Laurent, and that range of new enforcement mechanisms, a role for the United Nations and its human rights mechanisms in this kind of multi-level enforcement cocktail that you talked about, from Paul Duchamp.
So regarding the first question about essentially the meaning and scope of the rule of law, I would argue, it is in fact very much the position of the European Commission and the Venice Commission, that there is a core minimum understanding of the rule of law. So diversity of legal traditions in EU country, yes, but only this diversity should be compatible with the core minimum requirements of the rule of law. There is in fact a definition of the rule of law and its core components in the rule of law framework of 2014, adopted by the European Commission. And the core meaning of the rule of law promoted by the European Commission is very much the same as the one identified by the Venice Commission, the expert body, part of the Council of Europe. So I would argue that you cannot hide behind the diversity of national legal traditions in order to justify attacks on the core components of the rule of law. That being said, I would have nothing against member states going beyond the core minimum of the rule of law and finding ways of promoting better or enforcing in a stronger way these core minimum elements. That would be my answer to the first question. Regarding whether we should possibly emulate the UN peer review process, My understanding is that this is very much a recent proposal made by the Belgian government and with the support of the German government. The proposal is yet to be made public, so I cannot really comment on the key features of this mechanism. But I would say possibly we need to have something a bit more ambitious than the UN peer review process. I would say I would certainly like to see a more encompassing permanent mechanism, which would involve all of the EU institutions together. And this is very much, in fact, the scheme which has been promoted by the European Parliament on the back of a proposal made by a Dutch MEP named Sophie in 't Veld, who suggested in 2016 that we need some sort of a permanent monitoring and rule of law cycle in the context of which we would gather intelligence and therefore would make it easier to then enforce or initiate legal actions when there is a threat or an actual potential threat or a serious violation of the values on which the EU is based. So I would say possibly if we are going to adopt a new mechanism, I would rather have one single mechanism for involving all of the EU institutions rather than seeing each of the EU institutions adopting its own. We need a more coordinated approach. That would be my bottom line.
Can I just say something about the second question? I think that the UN obviously collects a vast amount of information from its monitoring. It has, at least 9 treaty body monitoring committees. So I think it can be used as a source of information for the EU. But I think that because there are specific EU law concerns that we want to be looking out for, there is value in having in the EU having its own monitoring mechanism. But the EU and the UN can collaborate on statements and try to align their efforts as far as possible.
Yeah, I would agree with Justine. We don't need to reinvent the wheel, but possibly we need to gather the information which is available out there in a more effective way as part of a permanent monitoring cycle. That's what I tried to say.
Excellent, thank you very much. And perhaps we can conclude just with a couple of final thoughts. There's a question specifically to Justine, but Laurent, you can come into this as well. And I think it's very relevant for our projects. Developing the idea of the role of education in engaging civil society in rule of law matters and justice and democracy and so on. From Dale Minishima Lowe. What kind of tools do you think we should be using and looking at in this area?
Well, I think that there are a lot. I mean, obviously, the sort of straightforward here is what the rule of law is, breaking it down as simply as possible. The institute where I work, we've tried to break it down into 5 ingredients. But there's also, just general work to be done about teaching them to teach people about their rights and to even learn lobbying skills or learn how to get involved in legislative drafting and sort of get involved in the processes when these governments are trying to make harmful laws and get them through, and really just sort of teaching them so that they can then go out and teach the communities about what the rule of law is and what their rights are, and yeah, that's basically it.
Okay, very good. Thank you very much for joining us today. This is all the time we have. I would like to thank our speakers, Professor Laurent Pech and Dr. Justine Stefanelli, as well as our audience members for taking part in this webinar. Before leaving you, I would like to announce some future Reconnect activities. The next Reconnect webinar is planned for the 17th of April with Professors Dmitry Kochanov and Petra Bard, entitled The Rule of Law Crisis in the New Member States of the EU, the Pitfalls of Overemphasizing Enforcement. And if you are in the Brussels area, on the 5th of July, we are organizing our yearly Reconnect conference where we will share the first findings of our project and take stock of the recent developments in European democracy and rule of law. For further information, please visit our website at reconnect-europe.eu. Thank you for joining us, and we hope you will join us again next time. From Laurent, Justine, and myself, thank you and goodbye.
Thank you.
Thank you.